2025, former President Rodrigo Duterte became the first Philippine head of state that has been arrested by an international court following a warrant by the International Criminal Court. The charges stem from allegations that Duterte orchestrated the creation of death squads responsible for thousands of extrajudicial executions targeted alleged drug users and traffickers during his tenure. Human rights groups say up to 30,000 drug suspects were executed during Mr. Duterte's controversial drug crackdowns, whereas local police claim the number to be closer to 6,000. Since its establishment in 2002, the International Criminal Court has issued 60 arrest warrants, resulting in 11 convictions and 4 acquittals. The ICC prosecutes individuals for the gravest offenses, including genocide, war crimes, crimes against humanity, and the crime of aggression. The arrest of former President Duterte has sparked a multitude of issues spanning legal, political, and social domains. On the legal aspect, there is the jurisdictional dispute. The Philippines withdrew from the ICC's Rome Statute in 2019. What are the implications of the withdrawal on ICC's jurisdiction? Does ICC have authority over crimes committed while the Philippines was a member from November 2011 to March 2019? Is the Philippine government obligated to comply with Article 59 of the Rome Statute, which provides that a person arrested shall be brought promptly before the competent judicial authority in the custodial state? It must be noted that Duterte was not brought before a court but was in the presence of officials from the DOJ, leaving room to contest whether or not the provision was strictly followed. However, some argue that since the Philippines is no longer a state party to the Rome Statute and that Article 59 does not strictly apply. Is Article 59 applicable only to state parties? Is the applicable law domestic law, or RA 9851, the Philippine Act on Crimes Against International Humanitarian Law, Genocide, and Other Crimes Against Humanity? There is also a question on due process. During his arrest at Manila's Ninoy Aquino International Airport, Duterte resisted procedures such as fingerprinting and threatened legal action, claiming violations of the constitutional rights. Does the arrest infringe upon national sovereignty and due process? For international issues, former President Duterte's arrest presents both an opportunity and a challenge for the ICC. The ICC is a widely recognized institution in global justice. However, the level of respect and legitimacy varies among nations, political leaders, and legal experts. While many countries and human rights organizations support its role in prosecuting war crimes, genocide, and crimes against humanity, others question its impartiality, effectiveness, and enforcement power. One challenge, for example, is that the ICC has issued several arrest warrants that remain unenforced, often due to lack of cooperation from member states of the non-recognition of the court's jurisdiction by certain countries, such as Sudan's Omar al-Bashir for crimes against humanity, war crimes, and genocide related to the Darfur conflict, Vladimir Putin for war crimes related to the invasion of Ukraine, Benjamin Netanyahu for war crimes and crimes against humanity during the Gaza conflict. Despite the many challenges that face the ICC, their efforts have led to 11 convictions. A few leaders have also been convicted by the ICC, mostly warlords and militia commanders. Many are thus monitoring the development of this case against a former head of state. On global human rights discourse, the case has reignited debates on human rights practices, the legitimacy of international legal bodies, and the balance between national sovereignty and global accountability. On the human rights advocacy, the arrest has roused the spirit of human rights organizations, validating their long-standing cries about extrajudicial killings and potentially influencing future advocacy strategies. We are here today to wade through the many questions that have arisen from these recent events. Conversations and discussions are crucial. A well-informed discussion prevents misinformation and political manipulation. Academic discussion clarifies complex legal terms, helping all of us to study and teach the law, and more importantly, for the public to understand the case's significance. I encourage everyone to engage thoughtfully, ask questions, and take full advantage of the insights of our esteemed panelists. Thank you very much.
Thank you very much, Dean Lelen. To introduce our panelists and start this afternoon's discussion, may I call on Associate Professor Rommel J. Cases, the Director of the Institute of International Legal Studies at the UP College of Law, who will be moderating the panel discussion.
Good afternoon to everyone in the Malcolm Theater and those joining us online in Zoom, and also those watching the live stream, and those in the, currently in the Malcolm Hall lobby watching the proceedings. It is my pleasure to introduce our first speaker this afternoon. Assistant Professor Michael Chu is a professor at the University of the Philippines College of Law. He is the head of the Institute of International Legal Studies International Criminal Law Research Program. Professor Chu is also the legal consultant with the United Nations Office on Drugs and Crime, or ODC, under the UN Joint Program for the Promotion and Protection of Human Rights in the Philippines. He is a consultant of the Supreme Court of the Philippines on gender policy and its Committee on Revision of Rules, and has been a consultant of the Commission on Human Rights on matters involving international human rights standards. He's also a member of the Philippine Working Group on Business and Human Rights, having conducted BHR trainings for several of the largest publicly listed companies in the Philippines. Professor Michael Chu obtained his bachelor's degree in political science in 2009 and his Juris Doctor degree in 2013 at the University of the Philippines. He was admitted to the Philippine Bar in 2014. He obtained his first Master of Laws degree in International Business Law from the Central European University, where he wrote his thesis on the liability of corporate agents for Rome Statute crimes. He also attended the winter session of the Hague Academy of International Law in 2020. Professor Chu is now, currently, at the University of Michigan Law School, Ann Arbor, for his second Master of Laws degree, where he is a Grotius Scholar. Ladies and gentlemen, Professor Michael Chu.
Thank you very much, Professor Rommel Cases. Magandang hapon po sa ating lahat at magandang umaga po sa amin dito sa bandang ito ng mundo. Let me share my presentation, and what I'll do in the time that is given to me is to talk about, to walk us through some of the items or some of the questions that you might already be asking, so that we'll save our interactions later for the good stuff that you really, really want to talk about today. But we might want to walk through some of these items to hit some of the things that you already are thinking of. Okay, so the first thing is, well, what's the charge, right? So the charge is crimes against humanity under Article 7, Paragraph 1A, which is the crime against humanity of murder. So it's important to note that under the warrant for arrest, the application for that warrant also wanted the warrant to be issued for the crime against humanity of torture, crime against humanity of rape, but the pretrial chamber only issued the warrant for murder because there was an insufficiency of evidence for those other two. The nexus, rather. They were committed, but the nexus to the attack had been insufficient. But we can expect that those two other crimes against humanity might also still be prosecuted or charged rather at this stage by the Office of the Prosecutor. All right. So, I'm giving you all of the text so that we're all on the same page about the rules that we're talking about. When does a warrant of arrest issue? Why do I put this here? I put this here because of the standard that is required to be satisfied for a warrant of arrest. You might be thinking, well, there's a warrant of arrest already. There must be strong evidence that the court had already appreciated in this particular case. That might be the case, but for purposes of the warrant of arrest, the standard is reasonable grounds to believe that the person has committed a crime within the jurisdiction of the court. That's the first requirement that has to be satisfied. Next, that the arrest is necessary. So it also is a different requirement, and it is necessary to ensure one of these things, no? To ensure the person's appearance at trial, that the person does not obstruct or endanger the investigation, or that the person does not continue committing the offenses. In the warrant of arrest, we will see that the court had noted that former President Duterte still wields considerable power in the country. And so that's one of the considerations in determining whether it was necessary to arrest him, because the other option would have been summons. But the court didn't think, the pretrial chamber rather, didn't think that that was feasible under the circumstances. Okay, so what does the standard of reasonable grounds to believe mean? In one case, the court had described it to mean evidence that need only establish a reasonable conclusion. So there could be other conclusions from the evidence, but at least from the body of evidence that we have so far, you can reasonably conclude that this person who is the subject of a warrant had committed the crime. So it's a pretty, I would say, less demanding standard compared to the others. Of course, the least demanding in the scale was the one that was used for the preliminary examination and authorization to proceed to investigation, which was the reasonable basis to proceed. Okay, we'll encounter other standards later. So I borrowed this from the ICC social media platforms. They've posted this. So you can see that the process is laid out here, and we're awaiting the first appearance stage, which will happen, I think, later. The court, the pretrial chamber had already announced that schedule. So what happens during the first appearance, right? So Article 60 tells us that upon the surrender of the person to the court and the first appearance happens, the pretrial chamber will have to satisfy that the person has been informed of the crimes, which is important, and that's also familiar to us in due process discourse in this country, that this person had been informed of his rights under the statute. So what rights those are, we'll do that later. And of course, this important remedy of the right to apply for interim release pending trial. So it is possible for the former president to be released from the detention facility pending trial. Okay, and how does that happen, right? So the court will check whether the requirements for the issuance of the warrant are still there, and if it is necessary to keep the person, then he won't be released. But if not, then he might be released, and any of the following conditions might be imposed. No, not all of them. The court will choose based on the circumstances which ones it might impose or might be reasonable under the circumstances. So often we are asked whether there is an equivalent to bail in this circumstance. There is under letter G, person must post bond or personal security or surety, but it's not the usual condition that is imposed, unlike in our jurisdiction. So this is under the rules of procedure and evidence of the court. 61 tells us about the next part of the process, which is the confirmation of charges. And I personally consider the confirmation of charges stage as a critical stage, because it is the stage that happens before the actual trial, or is determinative of whether we're having a trial at all or not. No? So 61 tells us that the standard here to confirm the charges, so the charge of, let's say, crime against humanity, of murder, is sufficient evidence to establish substantial grounds to believe that the person committed the crime charged. Mas mataas po siya doon sa reasonable grounds to believe that the person had committed a crime under the jurisdiction of the court. Ano po ang pwedeng gawin under the confirmation of charges stage, no? During the hearing, the person who was arrested, kasi hindi pa kumpirmado ang charges, so arrested person ito, may object to the charges, challenge the evidence, and of course, present evidence also to challenge the evidence of the other side. No? So in this stage, how do we understand the standards? Kung kanina, reasonable conclusion based on the evidence lang na nag-commit, itong taong ito ang nag-commit ng crime na ito, dito, kailangan mapakita ng Office of the Prosecutor na meron siyang konkreto at tangible na evidence in support of the charges at the confirmation hearing, and there's a clear direction in the reasoning supporting its specific allegations. So kung makikita niyo yung lengguwahe ng standard na ito, medyo mas exacting na siya doon sa standard na kailangan i-satisfy for a warrant of arrest. Lagi din tayong tinatanong, relevant ba yung age or health ni dating Pangulong Duterte? So, kahapon lamang or ilang oras ago, nakita natin na may announcements on medical examination or consult with a medical professional, and that was that they did that under this rule. But also, I think just the larger point is it might be relevant when somebody asserts that they are not fit to stand trial. So tulad ng sa atin dito, meron tayong konsepto ng kaya ba niyang maintindihan yung proceedings at fit ba siya to stand trial, at doon magmamatter yung kanyang edad o yung kanyang health or kalagayan, no? So ano ba yung fitness to stand trial? So itatanong dito kung yung akusado, kasi at this stage kumpirmado na yung charges, no? So sa confirmation of charges, two things can happen. Either hindi i-confirm yung charges, so walang paglilitis na magaganap, or i-confirm, in which case ito na yung mga issues na tinatalakay natin kasi may paglilitis na magaganap, no? For reasons of ill health, can this person meaningfully exercise his or her procedural rights? So kailangan meron siyang mga certain capacities to be able to understand what is happening and also to instruct counsel and make a statement. So hindi kailangan napakataas ng capacity na ito. Ang enough lang na naiintindihan niya at nakaka-instruct siya sa counsel. Okay. So, under the trial, of course, all of these, we have the benefit this afternoon of former Judge Raul Pangalangan, who can actually explain how this plays out because he had been presiding judge in a trial. So, but the provisions will tell us that the accused has to be present during the trial. So, makikita natin. And of course, if the trial is public, so we will be able to view that through live streaming. Pwede na lang kung may mga in-camera hearing. Okay, I put the here number 2 because we can expect, given previous experience, that something like this might happen. Okay, so Article 64 tells us that it has to be public, and then of course the trial chamber has to read the charges that had been confirmed by the pre-trial chamber. Okay, so meron din bang pagkakataon na i-consider yung admission of guilt? And that's a possibility. So Article 65 has provisions that will take care of when a person admits guilt, no? So kailangan, of course, same dito sa atin, familiar concepts na maintindihan ang nature and consequence of the admission, that it was voluntarily made, and that the admission of guilt is supported by the facts. Okay. What are the rights of the accused? So ito, I won't go through all of them. You will see that some of them are really familiar in our jurisdiction. We have them as well. One thing that I want to point out is without undue delay. That's right of the accused. And kasi maraming nagtatanong gaano ba katagal itong paglilitis na ito, no? And then, of course, meron ding right to counsel, to choose from a list of counsels that have been accredited by the court, and also interpreter, for example, tatanong din yan kung kailangan ng interpreter. And then that might also be provided. So, what about the victims? No, the Rome Statute also tells us that the victims may share their views, and the Rome Statute or the ICC really is a unique institution in the sense that there are so many mechanisms for the victims to participate. The victims are centered in this process, and of course, the entire thing about reparations for victims. So they can participate through the Victims' Council na iba sa prosecutor. All right. So what about the testimonies of witnesses? Kailangan ba nandoon sila? As a general rule, yes, nandoon sila, but hindi naman precluded, in fact allowed rather, na mag-record sila ng testimony or maggumamit sila ng technology, so video or audio technology to do that. What would the prosecutor need to prove during the trial? Well, these are the elements of the crime against humanity of murder. Yung number 2, ang tinatawag natin na contextual elements, parang overarching elements, no? Na merong attack against a civilian population, directed against a civilian population na widespread or systematic. No? So, or yan, widespread or systematic. Then yung actus reus, which is the perpetrator killed, or under the Rome Statute, killed could also mean caused the death of one or more persons. And number 3, that the conduct was part of the intended widespread or systematic attack. So kailangan may nexus yung pagpatay or yung killing doon sa widespread or systematic attack, which is the contextual element. And then, of course, kailangan isatisfy yung mens rea or yung mental elements na makikita natin under Article 30 of the Rome Statute, yung knowledge and intent, which are concepts that are also familiar to us. Okay, so ano ba ibig sabihin ng widespread? Paano ba yun nasa-satisfy? Either large geographical area or small geographical area, but directed against a large number of people. Okay? So, ang systematic naman, merong organized plan, so hindi siya isolated, hindi siya sporadic, isolated acts. And then, of course, that might mean na merong state or organizational policy. In this case, naiisip niyo na kung ano yung polisiya na yun, no? And it need not be expressed or written, as long as you can discern that policy from the evidence. This one is a potential interesting issue. Kasi yung warrant of arrest, ang charge ay as indirect, so mode of liability ay indirect co-perpetrator. So makikita natin under Article 25(3)(a) na combined ito. So paano ba nagiging co-perpetrator? So under A, if you can see the language, jointly with another person. So may kasama siya, no? That had committed the crime. So co-perpetrator sila. Pero paano ba nagiging indirect? Indirect kasi through another person, no? So hindi siya mismo ang gumawa ng killing, pinagawa niya sa iba. So yung nakita natin sa warrant of arrest, ang sinabi ay ginamit yung Davao Death Squad, for example, or nung naging presidente niya, yung state apparatus to commit these acts. And we also get questions about who are the other co-perpetrators. So we might expect that those co-perpetrators might also be subject of warrants of arrest in the near future. Ano bang ibig sabihin? Ano ba yung malaking konsepto dito sa indirect co-perpetrator? Ito yung tinatawag natin na control theory. So liable siya as a principal kasi kinokontrol, in other words, colloquially, mastermind, no? To physically carry out the objective elements, but even though they're not at the scene of the crime, meron silang control doon sa commission of the crime. I would say at this point, as an academic and maybe for public discourse, that the indirect co-perpetrator mode of liability has been discussed and in fact had been subject of different opinions by different ICC judges, especially in the case of Ntaganda in the appeals chamber. No? So we might have questions about that. And then sa huli, ano ba yung pwedeng ipataw na sentensya, no? Ano ba yung penalties? Lagi din tayong natatanong. So of course, imprisonment is an option, and hindi natin alam kung ilang taon yan hanggang matapos yung paglilitis, no? But of course, the maximum is only 30 years. In exceptional circumstances where there is extreme gravity of the crime and based on the individual circumstances of the convicted person, the term of life imprisonment may be imposed. In addition to that, pwedeng mag-fine, pwede ding forfeiture of proceeds. And the determination of the sentence will, of course, again, take into account gravity of the crime and individual circumstances. The International Criminal Court is unique because it is a combination of different legal cultures. No? So that's the end of my presentation, but I want to end by saying that it is unique because pwedeng iapila kung ano man yung hatol dito. So we are familiar na kapag conviction, pwedeng iapila ng convicted person yung hatol na yan. Pero under the Rome Statute, pwede din iapila yung acquittal under whether the ground is error of law, error of fact, or some other error in procedure that had affected the trial and the rights of the accused. So there. So looking forward to your questions later. Thank you.
But our next speaker is no less an expert himself, one of my former professors. Professor Teddy Te is assistant professor at the University of the Philippines. He's also a human rights lawyer and advocate for many human rights issues with Free Legal Assistance Group, or FLAG, the oldest human rights lawyers network in the country, which he joined after he passed the bar in 1991, and where he is currently the regional coordinator for Metro Manila. He has taught a broad range of subjects in 3 decades of academic life, including criminal law, civil and criminal procedure, evidence, special proceedings, special writs, labor law, and pioneered electives on law and medicine, martial law, jurisprudence, and international criminal law, and the law on transnational crimes. He has been bar examiner 3 times for criminal law, labor law, and procedure. He is currently the program head of the UP Law Clinical Legal Education Program and concurrently the clinic head of the Civil and Political Rights Clinic. He has litigated and continues to litigate cases at all levels of the court system, having presented oral arguments to the Court of Appeals as well as to the Supreme Court on many occasions, involving issues such as the constitutionality of the death penalty in the Philippines and the anti-terrorism law of 2020. He has represented journalists in libel and cyber libel suits and continues to do so. He has also given training to journalists to equip them against nuisance, defamation suits, and also training to NGOs and advocates against red tagging. He has filed communications before the international human rights bodies in representation of death row convicts, spoken in international domestic forums regarding abolition of capital punishment. Among his chief advocacies are the abolition of capital punishment, freedom of expression and freedom of the press, and the protection of civil and political rights. He was, from 2013 to 2018, the Chief Public Information Officer of the Supreme Court of the Philippines, acting as its de facto communicator to the media and to the public. He has written and lectured extensively on many aspects of human rights protection and defense, and is a regular resource person for media on many issues of the day. He's also an active podcaster and an occasional columnist with an active social media presence. He has degrees in psychology and in law, both from the University of the Philippines and a master's in law from an incredibly prestigious school, Columbia Law School. Professor Teddy Te.
Thank you, Professor Rommel. I'm afraid that my remarks might be shorter than my introduction, my brief introduction, but I wanted to give more time for the questions and answers, and I'm here essentially to maybe pick apart some of the domestic law and procedure issues as they relate now to international law. I think in the last 3 days, everyone has become a fan of public international law. A lot more have become experts on public international law. But this situation involving the Philippines before the ICC presents to us a very rich menu of issues. Uh, International criminal law, definitely, public international law, but there's also a lot of issues regarding domestic procedure. Let me just point out that currently there are several petitions before the Supreme Court. There are 3 petitions seeking the issuance of the writ of habeas corpus in favor of the former president, filed by 3 of his children. There is a pending petition for certiorari, prohibition, preliminary injunction, and temporary restraining order filed on behalf of the former president by his co-petitioner, Senator De La Rosa. And all of these petitions have been acted on by the Supreme Court. The petitions for habeas corpus have been consolidated, and the respondents through the Office of the Solicitor General have been directed to file their comment within 24 hours. As befits habeas corpus as a speedy remedy. And the petition for certiorari, prohibition with a prayer for injunction and restraining order has also been acted upon by the Supreme Court. The restraining order that prayed for was denied by the Supreme Court, not because it was moot and academic, as many were speculating, but as the court said, because there was no clear legal right that was detailed in the petition. We can discuss that and the implications of that on the petition itself in a bit more detail maybe later. But also there are several other issues that are presented in the petition for certiorari, prohibition, injunction, and restraining order filed by petitioners De La Rosa and Duterte before the court, which may actually lead the court to take action. What has piqued my curiosity here in this entire situation is the interplay of domestic remedies in relation to the international situation. One very specific issue, for example, because I also teach an elective on habeas corpus, is whether or not our court will find that the petition that a writ of habeas corpus can actually be issued and can actually affect someone outside the territory of the Philippines. In the United States Supreme Court, of course, that issue was resolved in relation to the war on terror of President George W. Bush, Boumediene versus Bush, where the Supreme Court of the United States ruled that a non-U.S. citizen who was detained in a U.S. territory outside of the U.S., i.e. Guantanamo, was entitled to federal habeas. And the court actually granted it. We don't have yet a similar ruling because this issue has never been presented to the court. And so the question of whether the Supreme Court will scratch that itch is something that I'm also looking forward to. The court could also, however, simply take the easier way out, as it were, by simply saying, well, it is moot and academic. It is because he is no longer here. But I wanted to point out also that in the petition filed by petitioner De La Rosa, he indicated that he has legal standing to bring the petition because he may be affected directly. So I am not sure whether petitioner De La Rosa knows something we don't, but of course, students of judicial review will know the issue of ripeness as well as standing are crucial to the Supreme Court when the court reviews a petition. So I do not know whether the court will actually just simply say the petition is premature because, well, Senator De La Rosa is still very much around, or whether the court will favor him with a declaration, which we also know because in the petition for certiorari and prohibition, the petitioners are asking for a declaration, which may, to the court, sound like a request for advisory opinion or declaratory relief, which the court has no jurisdiction over. So as I said, a very rich menu of issues and items. So I will cede a lot more time to my fellow panelists, particularly, of course, Professor Emeritus and former Judge Raul Pangalangan, because I think everyone is looking forward to hearing his insights from someone who has served on the International Criminal Court, and look forward to your questions later. Thank you very much.
Thank you very much, Professor Tedite. So from a former professor, let me move to a former student who's now also teaching in the College of Law, Attorney Ruby Rosel L. Tugade. Ross is a senior lecturer at the University of the Philippines College of Law and a senior legal associate at the Institute of International Legal Studies of the UP Law Center. Attorney Tugade's international criminal law work is built on her experience in the field as a legal analyst of international crimes. Working with international prosecutors and victim lawyers, Attorney Tugade was involved in teams that capacitated field investigators and other local justice actors to examine evidence and build crimes against humanity and war crimes cases in the Korean Peninsula and Ukraine. Prior to her international legal work, Attorney Tugade worked extensively in the Philippine human rights space in various capacities. She was an attorney with the Commission on Human Rights, helping build the first CHR report on drug war killings. She then worked as a public interest lawyer with Center Law, whose clients included a community of drug war victim families. As an independent consultant for civil society organizations, Attorney Tugade supported different human rights projects on accountability pathways. She's a member of the Free Legal Assistance Group also, FLAG. Attorney Tugade has published scholarly work on international human rights, international humanitarian law, transitional justice, and general international law, appearing in international and local law journals, edited academic volumes, and peer-reviewed online platforms. She currently sits in the editorial board of the Feminist Legal Studies and the IBP Journal. Attorney Tugade has degrees from the Ateneo de Manila University, the University of the Philippines College of Law, and the United Nations Interregional Crime and Justice Research Institute in Turin, Italy, for her LLM. She will commence her PhD in law at the Faculty of Law and Justice of the University of New South Wales as an Australian Government Research and Training Program Scholar later this year. Ladies and gentlemen, Attorney Tugade.
Thank you, sir. So I wish to anchor my discussion, as you've heard from the brief introduction, that I have worked mainly in the field, but now transitioning into a more academic role. So it will be a mix of both. Okay, so I'm sure most of us have paid attention to the charges or the potential charges that may be confirmed later in the coming weeks against President Duterte. And we focus on crimes against humanity, which Mike has already discussed, the contextual elements or the chapeau elements during his presentation. So usually, and for my students who are in the audience, one of my favorite phrases to say in class is the Nuremberg moment. My classmates, my students remember. So I usually preface any academic discussion on these core crimes, their history, and the development of the doctrine from Nuremberg up to the ad hoc tribunals in the 90s and now in the ICC. So there is another time and place for that, and in the interest of time, I take it upon myself today to ground crimes against humanity on its more practical dimension. So for those trained in the domestic legal system, we prove crimes or felonies under the RPC using specific elements. Right? These are the things that we memorize in criminal law too. In international criminal prosecutions, we prove the contextual elements of international crimes as a first level of analysis in conjunction with the specific actus reus. Murder, torture, rape, enforced disappearance, persecution, etc., which are listed in the Rome Statute. The context of international crimes is the very thing that makes them international crimes, as opposed to individual or isolated acts of criminality that can be prosecuted domestically. In this sense, it is quite inaccurate to say that crimes against humanity is merely a predicate crime. This language does not appear in the Rome Statute. Also, to clarify some posts going around online. Instead, the crime against humanity of murder is the crime itself. Okay? So on to crimes against humanity, the context has to be demonstrated. So part of the description is that it should be part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. Notice the language, and let's walk through the contextual elements. Part of the attack. There is a pattern or a modus operandi that is implied here, which will be very crucial for legally characterizing the charges later on. Simply, what is the pattern of criminality? It could be the same style of killing, meaning, for example, barging into houses, cutting off barangay CCTVs, the killing, and then up to the delivery to the funeral homes. This could be one pattern of criminality. Same perpetrator group, same area, same temporal span. Widespread or systematic attack, as Mike has also mentioned, widespread or systematic. So what separates these two phrases or these two qualifiers is the word or. So it's either. Widespread means pertains to the number or numerous, while systematic implies organized or orchestrated. And then when it comes to attack on the civilian population, attack here is not in the same sense as attack under the UN Charter. So attack here is not armed attack in the sense of a military attack, and civilian population is simply the population in its entirety, meaning belligerent status is not considered in crimes against humanity. So it can happen even during contexts where there is no active armed conflict. And lastly, on the contextual elements, there is the knowledge of the attack, meaning that there is knowledge that the incident of violence is part of the larger pattern of criminality. If it is a crimes against humanity of murder, we prove the context and also the specific element of murder, which is the killing of a person or persons through the pattern of criminality. We prove murder using the same evidence, testimonial, forensics, even digital evidence. And for the pattern, this is where the other classes of witnesses can come in. Pattern witnesses, such as those who have observed the modus operandi, can be called as witnesses. Insider witnesses who themselves could have been part of the perpetrator group. Expert witnesses, for example, experts on forensics, ballistics, etc. And then we have overview witnesses who may testify as to the political system, the political context of the particular place where the crimes have occurred. Notice that by definition of a crime against humanity, it requires widespread or systematic, but in the language, there is no requirement of the use per se of the state apparatus. But in the Philippine case, and which can be gleaned from the request of the issuance of a warrant, there is a reference to a common plan. And notice that this was typed in title case, capital C, capital P, the common plan. This is the articulation of the system or the organization, which is required to establish the contextual elements of a crime against humanity. So there are also talking points online that the relatively small number indicated in the warrant, as opposed to estimates during the drug war speak of up to 30,000 deaths, that in effect would make the allegations not constitute a crimes against humanity. There is no threshold number in the Rome Statute as to the required number of victims that would already make it a crimes against humanity case. So in international criminal investigations, we gather all evidence, we systematically organize them to make sense of the criminal pattern. So I will keep on saying this word, patterns of evidence, or patterns of criminality related to the overarching scheme. Okay? In any case, there is a feature of the Rome Statute, and perhaps Professor Emeritus Pangalangan can expound more on this, that one unique feature of the ICC is that it sort of distorts the role of the prosecutor such that the office of the prosecutor may be allowed to continue doing some investigative work. At this point, I will diverge a bit and contextualize the fine distinction between international criminal investigations and human rights documentations. Human rights documentation is very crucial and valuable in any mass atrocity event, such as the drug war. This is why all the tireless and brave colleagues in the human rights space and our even braver victim community have been instrumental in gathering and preserving the documents and the evidentiary material related to the drug war. The role of international criminal legal analysts and international criminal lawyers is to now take all of this human rights documentation and to make sense of it. To make sense of it, organize it, and to ensure they fit into the legal characterization of a potential trial for crimes against humanity. This is now the realm of international criminal law. So we organize the documentation to surface the patterns, the trends, the incidents throughout a span of time or a geographic scope and the usual modus operandi of criminality. This will help refine the specific charges that will be formulated by the prosecutor in the coming weeks, days or weeks. The threshold to confirm the charges, as mentioned by Professor Chu, and notice the language, will now be elevated to substantial grounds to believe that the person committed the crime charged. The person is now tied to the charges. Okay? So this is why when the confirmation of charges hearing will start, we will have a glimpse of a sneak peek of the prosecutorial strategy that might happen. The prosecutor with his staff of investigators and lawyers will have to formulate the specific charges in what we call the document containing the charges. It could be crimes against humanity of murder for killings that took place in, let's say, X city or X province during X year and so forth. The document, like the application for the warrant, will also indicate the mode of liability for the perpetrator. And as mentioned a while ago by Professor Chu, right now we're looking specific to former President Duterte, Article 25(2)(a, or indirect co-perpetration. Indirect co-perpetration sort of improves on the older modes of liability in other international criminal cases, particularly in Nuremberg and in the ICTY, which is on the former Yugoslavia, and the ICTR. So before we had the concept of what we call joint criminal enterprise, which I will not go into detail, and also direct commission, direct co-commission. Now, indirect co-perpetration, it requires a detailed analysis, and I have to emphasize this. It requires a detailed analysis of the organizational structure through which the crime was committed. Okay? Is it the same as command responsibility might be one question now. No, it is not. Command responsibility is governed by another provision of the Rome Statute, Article 28, which says, quote, a superior shall be criminally responsible for crimes within the jurisdiction of the court committed by subordinates under his or her effective authority and control as a result of his or her failure to exercise control properly over such subordinates. Notice the hook, okay, the hook on the liability here. It is failure to exercise control if it is command responsibility. An international criminal investigation will also necessarily entail what we call the gathering of linkage evidence. Right? Linkage evidence, or evidence as to the chain of command, the reward or incentive system, who gave orders, etc. This is something that the ICC will definitely look into. Now, with victim participation, which is crucial in the ICC, they can participate as informants or direct witnesses of the crimes. In the ICC's model, victims will aid the court in clarifying what happened, and this is the reason why victim representation in the ICC is separate from the work of the prosecutor, and this is governed by Article 68 of the Rome Statute. There are certain offices within the ICC that might be relevant with respect to the participation of victims. We have the Victims and Witnesses Unit, who may advise the prosecutor and the court on appropriate protective measures, security arrangements, counseling, and assistance. The VPRS, or the Victim Participation and Reparation Section, which will provide all relevant information, forms, documentation, etc., and other data that the victims might need. and the Office of the Public Counsel for the victims, which provides legal representation to victims throughout the proceedings, as well as assistance and support to external lawyers who may be appointed by the victims themselves. Okay? And as a final note, and this is where I now shift to my academic hat, there are fair criticisms upon the court, anchored on the perception that it is ineffective. It's a mere tool of the West. And my view now as an academic is to see the critique for what it is and examine its contingency on the context and history. And across cases where there is a call for international criminal accountability, not just in the Philippines, there is a cautious yet hopeful articulation of what can be done in the ICC and through international law. We cannot simply dismiss the calls for justice and accountability through international law, and we can recognize similarly that international law has been grounded on very complex imperial and colonial histories. And this is the work of longer, broader, deeper academic thinking and scholarly attempts to examine international law as what scholars would contemporarily call as a field or a discipline in crisis. But in the coming days, the task for our community, or community of practice, is also to see how some forms of justice can be possible. Thank you.
Thank you, Ross. And for our fourth, but certainly not the least speaker, all our previous speakers referred to him in their presentations. Our final speaker, before we go into the question and answer part of our forum or colloquium today, is former ICC judge, Raul C. Pangalangan, who was a judge at the International Criminal Court at The Hague until 2021. And has resumed teaching at the University of the Philippines, where he earlier served as law dean. He has lectured at the Hague Academy of International Law, where he had earlier been director of studies. He recently chaired the ILO Commission of Inquiry on Myanmar on freedom of association and forced labor. He has been elected to the Institut de Droit International, the foremost organization of international law jurists. He's currently a member of the Permanent Court of Arbitration at The Hague and a judge of the Administrative Tribunal of the World Bank and the Asian Development Bank. He received his LLM and SJD from Harvard University, where he won the Lenin Prize in International Law for his LLM thesis in 1986, and the Sumner Prize on Issues Relating to International Peace for his SJD dissertation in 1990. He received his diploma from the Hague Academy of International Law in 1987. Ladies and gentlemen, former judge of the ICC, Professor Emeritus, Judge Raul C. Pangalangan.
Rommel, thank you so much for that very kind introduction. First of all, I'd like to congratulate Dean Lennon for organizing this. Is there a problem with the sound? Can someone tell me? Because there's some. Okay. I will continue, and someone please tell me if I'm not making sense. Okay.
This end,
So,
let's continue.
Okay. Thank you so much. Maybe I should. Okay. I think it's my microphone. Well, let me begin afresh. Rommel, thank you so much for the kind introduction. And Dean Lennon, congratulations for initiating this forum. I think exactly as you said, it is important that we as a law faculty engage in the passion of our times, and that we join hands in pushing for a informed public debate and elevating a Filipino discourse on the pressing issues of our day. It is also a way, since Dean Lennon emphasized the importance of academic discussion, a way of rising above rising above partisan posturing on the issue, and getting to the heart of the matter. So you've heard the presentations of my colleagues, Teddy, Mike, Ross. They have covered the ground very ably, and I thank them actually for making my job easier as the last speaker. Okay. Since I returned from The Hague in 2021, I found the real challenge in explaining the ICC in the Philippines is that we tend to make it fit into familiar categories. In other words, we have old tools, and then we just try to we try to see them solely in terms of the old familiar boxes that we know. And I think at the outset, and this is the point I would like to make, we have to recognize that in many ways, the international criminal law, international criminal tribunals, are in a class of themselves. They are sui generis. I will give you examples. Let me start with the first. Duterte arrived in the Netherlands. He did not have a visa. Can you imagine any of you entering a foreign territory without a visa? And yet, he was allowed to enter. He was welcomed at the airport. Of course, he was no sooner brought to the jail. But notice the rest of the passengers of that airplane were initially prevented from disembarking. Again, precisely, they did not have any visa. And they were allowed to disembark only upon the representations of our embassy, led by Ambassador Ed Balaya, giving the usual consular assistance to Filipino nationals, who was able to arrange a visa for the lawyer of the former president, for the arresting party, I understand, for a nurse, for the companions of the former president. In other words, if you just followed the rules, the familiar rules that we knew, former President Duterte would have been treated exactly the way the other passengers of that airplane were treated, that the Dutch authorities would require them to have a visa. And in this case, no. And why? Because, let's face it, the host country is the Netherlands. The ICC is based in The Hague. They have a host agreement with the Dutch government, and that's part of the deal. In fact, I myself, as a judge, realized that sort of anomaly only when at some point in the court we acquitted someone who had been in jail for 10 years. And everyone realized, oh, if we released him, just like that, as ordered by the court, he steps out of the gates of the Scheveningen prison, and at that instant he becomes an illegal alien, a TNT. And so there had to be special arrangements made to deal with that phenomenon. So I'm just starting with the most practical, down-to-earth example of why we can't deal with this situation with the familiar rituals and rules that we know. Let me proceed to my next point. In the Philippines, first we have the filing of the information, the charges, and then based on the charges, the court issues a warrant of arrest. In the ICC, it's the other way around. If you notice, the next stage after the arrest of former President Duterte, the next stage is actually the confirmation of charges. Well, the hearing tomorrow is not actually confirmation of charges. That hearing will be it's called the initial hearing, where basically the court just familiarizes itself, just to confirm the identity of the person who was arrested, and to make sure that the identity corresponds with the person subject of the order. This was fully covered by Professor Michael Tew earlier. But notice that when the sequence is reversed, it also reflects the mixed origins of ICC law and procedure. Our procedure is mainly American. The ICC procedure is heavily influenced by the continental legal tradition. And so what happens now is that the person is now in the custody of the court. In a short while, the confirmation of charges hearing will be scheduled, and that is when he will have what we in the Philippines will consider the arraignment. When we don't use those terms at The Hague. When he's read the charges and when he is asked to assure the court that he has read that he understands the charges, and that he will be asked how he pleads to these charges. Okay, that's the second difference. Now let me proceed to the rather one of the most contentious issues the past 2 days, the legality of the arrest. Let us start from a fundamental principle. The ICC does not allow trials in absentia. So the presence of the accused is indispensable to the procedure in the ICC. And the warrant of arrest is the mechanism by which that presence is ensured. So we must interpret these rules in the context of that imperative, an imperative which is actually not just for the benefit of the accused, that he should be present when he is tried by a court, but also indispensable to the integrity of the proceedings before the court. Look at the history of international criminal law. The biggest cases in this field have not inquired into the legality of the manner by which the accused is brought before the tribunal, the manner by which the court acquires jurisdiction over the person of the accused. We begin with Adolf Eichmann, the Nazi who was basically kidnapped from Latin America, brought to Israel to be tried for the crimes committed in World War II. The court basically said, look, we have jurisdiction over the crime charge, that is material jurisdiction. We have jurisdiction over the person of the accused, that's personal jurisdiction. He was there physically, and we proceed with the case. That's Adolf Eichmann. That was actually more recently affirmed in an American case by the U.S. Supreme Court, U.S. versus Alvarez Machain. He was a Mexican doctor who was implicated in the torture of American DEA agents. And, well, he was basically kidnapped from Mexico and brought to the U.S. for trial, went all the way to the U.S. Supreme Court. And the U.S. Supreme Court says, well, we won't inquire into the manner by which he was brought into the jurisdiction of the court. We will proceed to give him a fair trial with all the guarantees. But the court did not inquire as to what happened before before the person appeared before it. But let me deal with you with a case in which I personally sat as judge, the case of Dominic Ongwen, a rebel commander in Uganda, tried by the court, convicted. I sat as a member of that trial chamber. And so I sat in the trial chamber. But if you look at the record of the pre-trial chamber, which is the stage, as explained earlier by Mike, but at the pre-trial chamber, there was a question about how the court acquired jurisdiction over Ongwen. You see, he wasn't he was actually captured by well, the wording was by troops of the Central African Republic in cooperation with the U.S. Armed Forces. Well, stated plainly, he was captured and brought in a U.S. helicopter. What did the court say? Notice, in that case, although when was brought to the court, he wasn't presented before any judicial proceeding, whether it was in the Central African Republic or the Democratic Republic of the Congo, nothing of that sort. He was simply hauled off into the helicopter, brought to the ICC. What did the pretrial chamber say? I will read. The court, the rules on the proceedings to be met by the custodial state, meaning the state that arrested him. These rules do not in themselves create a duty of the surrendering state to undertake any particular process upon the arrest of the person. And toward the end, the court said, in validating the arrest, said, to do otherwise is a disincentive to constructive cooperation between the court and the state, to the detriment of the interests of the ICC itself. So notice, the stance of the court confronts a very practical need. You see, the wheels of justice won't move forward unless the person is within the jurisdiction of the court. The arrest is indispensable to that. And that is why the court in this case did not look into the circumstances by which the person was arrested. If I may put another spin to it, notice that the wording of the rules, which are cited I've followed some of the debates on the duties of the custodial state to present the arrested person before some authority, etc., etc. These are not rights of the accused. The rights of the accused are listed specifically in the Rome Statute. That is the right to the presumption of innocence, to be found guilty only with proof beyond reasonable doubt, the right to due process, the right to counsel of one's own choosing, the right to confront witnesses, the right to be informed of the charges in a language that he knows and understands well. These are all the rights of the accused. There is no such thing as a right of the accused to be presented before a domestic tribunal. If at all, it is actually a duty of the custodial state. But notice in this, when you read the statute, it is the duty of a member state. So for me, we then face the irony that those people invoking this provision are telling us that the Philippines is no longer a member of the Rome Statute, and then they want to invoke duties of this non-member of the Rome Statute under the, ironically, under the Rome Statute, Rome Statute itself. Let me proceed to the next of the contentious issues here, complementarity. You see, there is a fundamental transformation in the case at this stage. Notice, up until the stage of the preliminary examination and the stage of investigation, go to the website of the ICC. What is listed there? It is called The Situation in the Republic of the Philippines. That is, in fact, the title of our entire forum. At this stage, we already have an accused. So very soon as we have the initial hearing tomorrow, and the confirmation of charges hearings is scheduled, you will have a new item in that website. It will be called Prosecutor versus Rodrigo Roa Duterte. In other words, the proceeding has morphed into the investigation of a situation in a country, which made the Philippines a situation country in the jargon of the court. into a proceeding against an individual who is now charged of a specific crime and who is being tried before the court. What is the effect of this transformation on the doctrine of complementarity? The principle stands. The principle is intact. The Philippines should have the first shot at prosecuting the offense. That is the fundamental rule in the ICC, the principle of complementarity. But notice, when we were still just a situation country, the debate on complementarity, the basic argument is of those who object to the ICC is like, hey, ICC, don't get into this, don't investigate the Philippines. There are problems here. We are investigating them. We are acting upon them. We are trying these cases. Stay out of it. We have exercised our national prerogative to try these cases. That's the argument. And therefore, to support that argument, they should prove that they are investigating the cases. You can go by the record of 6,000, which is the number used in the ICC documents. You can go by the higher documents, by the higher numbers raised in other documents. Okay. But they should show then that there are many cases that have been investigated, trials that have been conducted, and hopefully convictions that have been that have resulted from these cases. That is for the situation country stage. But now we have an actual accused. Complementarity becomes very simple. He can say that, hey, court, ICC, you can't try me. I'm already being tried by by a court in my country. So you can't try me all over again. You have to defer to the trial in my country. Well, I think the fact is, as we all know, there is no such case against Duterte in the Philippines. And therefore, what complementarity are we talking about? There is simply no case in the Philippines. The fact is there were thousands of killings. The wheels of justice have moved quite slowly. And as against this particular accused, no case has been filed. So for me, that should settle the point on complementarity. I expect that this will be raised. It will be raised during the confirmation of charges stage. Let me just try to move faster on the other points. Other differences, unique elements in the court. In the Philippines, for instance, we assume that lawyers will rehearse their witnesses. That is a witness coaching. That is allowed in the Philippines. It is actually encouraged in the Philippines. It is actually even glorified. In the ICC, it is a crime. My very first case assignment in the court was against lawyers who, well, engaged in witness tampering. And I told my colleagues, in the Philippines, we have such a thing as the judicial affidavit, where the lawyer basically drafts the Q&A of what was supposed to have been his direct, the witness's direct testimony. And everyone was simply aghast when I told them that. I told them, it saves a lot of time. But you see, again, depending on the legal system that you're familiar with, from within the ICC framework, it is simply unthinkable. We call it the Article 70 offense. And lawyers have been jailed for that offense. In fact, the one dramatic moment in that case was that they appeared in court for a hearing. And, well, before the hearing was over, they were hauled off to jail. So that's, for me, that's one, well, stark difference between what we're familiar with in the Philippines and what is done at the ICC. My colleagues earlier mentioned about the appearance of witnesses. Well, the court has allowed video link testimony, that is by I don't know, maybe by Zoom or by some software. And I can say that it is quite effective. And it'll might be difficult if the witness is testifying in the Philippines. There is a 6 or sometimes 7 hour time difference between the two time zones, but that's a complication that can be solved. The other thing is that, at the ICC, the witnesses are highly protected. We call upon witnesses, fully knowing that it is they testify at great risks to their person, to the safety of their families, to those who have been traumatized. We are aware that we are asking them to relive a difficult moment in their lives. They are given full support when they come to the court. They are given psychological assistance at every stage of their testimony and for the whole period that they are at the Hague. Let me just close on 2 points. Ross Tugade mentioned what we call the modes of attribution. That is how the accused is linked to the crime of which he is charged. And in this case, as Ross has mentioned, ex-President Duterte was linked as an indirect perpetrator. Number one, before this moment, many of the discussions had assumed that he would be linked through command responsibility. Well, it turns out the prosecutor chose a different path, that is indirect perpetrator. Now, again, this is a debated matter. Some people say that a direct perpetrator has more moral culpability compared to the indirect perpetrator. In other words, that the pressure therefore is upon us to find a way by which to link the accused as a direct perpetrator so that we can emphasize his moral culpability. The other approach, and this is what I've seen in the court, is that it doesn't mean that the indirect perpetrator is less evil compared to the direct perpetrator. In this case, the direct perpetrator is the gunman, the indirect perpetrator is the mastermind. The approach, well, the emerging approach at the court is that the mode of attribution is simply a way by which to link the accused to the crime. It does not reflect upon the moral responsibility, the culpability of the accused. And but that debate continue. My last point. When you enter the courtroom at the ICC, it is different from the Filipino courtroom. For us, there will be 2 sets of lawyers, the prosecution and the defense. In the ICC, there are 3 sets of lawyers. The third will be the legal representative of victims. That is the right of the victims to participate in the proceedings, to present their own witnesses, to cross-examine the witnesses of the other 2 legal teams, and that is done through the legal representative of victims. And for me, I close on this point because it is indispensable for a criminal proceeding to move forward without witnesses. And some of the witnesses are themselves victims or relatives of victims, and it is important for their voice to be heard. No criminal case can move forward unless there are witnesses who who are brave enough to step forward and speak their truth before the court. And it is my hope that the Filipino groups, the lawyers groups, the NGOs will continue to support the court in looking for witnesses and in encouraging witnesses to testify, winning their trust, and of course giving them support through this difficult process. I have spoken, purely by chance to many of these lawyers. Some of them are, well, many of them are my former students. There are religious groups led by Father Flavi Villanueva, for instance, who have done excellent work in the course of this case. And it is my hope that it is through their efforts that the truth will be established and that the victims will have their justice. Thank you.
Okay, thank you very much, Judge Raul. And now we move on to the, I guess, questions and answer portion of our colloquium today. When you registered, you were given the opportunity to submit your questions. And during the course of this event, some of you also submitted your questions using the QR code. You can still continue to do so until the time runs out for our question and answer. The questions are given to me in real time, hopefully, as the internet holds up. But I'll start off with the questions that were previously submitted as part of the registration process. Now, amazingly, many of the questions were actually already answered by the presentation. So what do I do now? No, there are still other questions that can be asked. So maybe we can deal with the questions in a temporal sequence. So let's begin with questions pertaining to the arrest. Right. So let's begin with that. And I suppose can I invite? I forgot. My former professor, Teddy Ted, to join it, to please sit, and my former student, Ross, to sit next to him over there, and then Judge. I'm so excited, I forgot. So Judge Raul and Mike will be on screen, who we really appreciate because it's currently 3 a.m. Where they are. So thank you for your sacrifice in joining us today. So let me start. I guess this is a question for Professor Te, although the others can also chime in, which it deals with the arrest. As someone who is familiar with local law and validity of arrests and all of that, the question that was posed was, would you describe the arrest of former President Duterte as by the book? Meaning, did the arrest of the former president follow Philippine law and the Rome Statute? So the others can also chime in if they want to. Were there any violations? And if there are any violations, I suppose, for Professor Te can point it out, what were they if it was not by the book? So, Professor Te?
Well, in the first place, the arrest was by virtue of a warrant issued by the ICC, not by virtue of a warrant issued by a local court. So as Judge Raul points out, we should be answering it within that frame. So if we're going by the book, I would suppose, given what I've seen of snippets of video of the actual arrest, because we weren't privy to what was going on at that actual time, I would say that yes, it went by the book, and I hope I don't get sanctioned by the Supreme Court because they're dealing with petitions challenging that very issue, but this is part of my academic freedom as part of the university. And so, but yes, I would say yes, it went by the book. So I don't think there were any, irregularities in that sense. I noticed many reports saying that he was read his Miranda rights, which technically doesn't, you know, it doesn't apply in the sense that he is not charged with any criminal offense in the Philippines, as Judge Raul points out. And so, but even that particular step was, I think, a step that was taken with great prudence, just to make sure that he understood that there were certain rights that protected him, even though he's not an accused in relation to a crime or a felony under Philippine law. Maybe Ross would like to add something more.
Thank you, Professor Te. The other speakers would like to speak. Is there a Rome Statute ICC related matter dealing with the manner of arrest? As I remember Judge Pangalangan's presentation, he did point out that in the past, in the history of international criminal law, the manner by which the person is taken is not really looked into. So would the others have anything else to add? Professor Mike, Professor Ross, Judge, anything else to add? I see none. Okay. Judge Raul, yes, go ahead.
Let me jump in, Rommel. You see, well, there are established procedure for carrying out arrests in the Philippines under the Philippine Constitution. But you know, there are actually exceptions, and we have accepted them rather comfortably in Philippine law. Take a look at extradition. In extradition, the judicial examination does not look into the sufficiency, doesn't look into probable cause. It does not look into the content of the charges. The only question in extradition proceedings before a local court is whether the person is being requested for an extraditable offense. Because for let's say a Philippine prosecutor to make a de novo determination of probable cause is to second guess the probable cause determination of another jurisdiction, of evidence to which he was not privy. So in other words, for me, that's why I began by saying that we shouldn't be stuck in the comfort zone, so to speak. Is that we have many exceptions to well-settled rules. We have accepted the rules, but we have also accepted the exceptions. And now suddenly with the ICC, we pretend that the rules have been so clear and there have been no exceptions whatsoever all along. I'll just give you another example. Detention pending deportation. You don't follow the usual proceedings for that, and yet that person, the deportee, is actually arrested and eventually expelled from the country. Anyway, I'll close with that point.
Okay. Thank you, Judge Raul. Now, Judge mentioned extradition, and in certain social media posts, it has been argued by a few that the process there should have been extradition proceedings. Now, I know Ross is raring to answer this, but I open the floor to the panel as well. I mean, is it really required that there be extradition proceedings before sending former President Duterte to The Hague? Ross?
So under the Rome Statute, it's surrender or extradition, and extradition would imply another state is involved. And in the case of former President Duterte, it was a surrender by the textual definition of the Rome Statute, not an extradition.
Okay. Anything else to add from the rest? Okay. So we are all in agreement, at least on this side of the panel. Okay. Let's go back. Again, we're dealing with this a bit sequentially in terms of time. So let's go back to the Supreme Court. Sorry, Professor Ted, back to you. You did mention a number of petitions that have been filed, habeas corpus, a TRO. First, on the the possibility of a conflict, right? I mean, how will this work? I mean, can we, I guess the question for you would be, from the point of view of the Supreme Court, would this be something that the Supreme Court would likely do, considering that President Duterte is already currently in the Hague? What happens if the Supreme Court rules a particular way, and the ruling is different? So we have a case of possible kind of fragmentation, not really, but at least a conflict of decisions from two courts. Is this, first of all, is this in the mind of the court? Would the court even think about that, or it doesn't matter to them? They would just rule, any way they want, regardless of whatever the ruling would be in The Hague.
I think we can pick up a few hints from how the court dealt with the petitions as they were filed. First, it acted on the petitions by having them raffled immediately so that they could consider options. Second, they denied the TRO, not by citing that it was moot because the former president was already out of the country, but by stating very clearly that there was no clear legal right to justify the immediate restraint. And by doing that, they were, I think, aware of the consequences, that having now a subject of the petition who is out of the country, effectively out of the reach of orders and resolutions of the court, I am pretty sure they are aware of what they can and cannot do within the powers that they have. So the questions I think that they would be looking at is whether, in fact, they could actually even review this entire thing. As far as the certiorari and prohibition petition of Senator De La Rosa is concerned, because that is the petition that challenges directly the jurisdiction and seeks to have a declaration that everything that was done was void, basically asking for a judicial review of all the acts that were done. The second issue, I think, relates to habeas corpus, and that, I think, presents a more interesting, a more nuanced issue, because here they're asking for a justification for the arrest and the detention. But again, looking at the petitions, they're also based on jurisdiction. They're also based on the fact that the Philippines has already withdrawn from the Rome Statute. So again, questions about, and I know that Professor Dan recently spoke about this, he might not like this, but essentially placing them out of the review of the court, essentially, what another form maybe of a political question, because the court really cannot take a look at the issue of jurisdiction of the ICC, and in practical terms, could they actually render a decision that said ICC was wrong in issuing the warrant? They cannot review the ICC warrant and the manner by which the ICC enforced the warrant and the manner by which the former president is now detained. The court is a practical court, regardless of how we may think of the court. They will look at that. They will see if their resolutions and orders could still address the issues. So I won't second guess what they will do, but I'll just leave it there. The court is a practical court. They will realize, I think they will see the extent of what they can do given the circumstances at hand. But I think the initial way they dealt with the petitions it gives us a hint as to how they would prefer to handle the situation.
Okay. Thank you very much, Professor Ted. I think Mike would like to say something. Also, if you could add, from the point of view of the ICC, how would they view these current? Would it affect their actions in any way, knowing that there are these current petitions before the Supreme Court? So we'll start with Professor Mike.
Yeah, from the point of view of the ICC, I don't think that those would be relevant questions, the domestic proceedings before a domestic court. So they would be performing functions under the statute where their mandate comes from, so they would be blind to these proceedings, although we can expect that these matters might also be put forward. I think just one interesting question that we might anticipate is the consideration, we are sure that in some of these petitions, some constitutional rights might be asserted. So it will be interesting how the Supreme Court will look at how that will play out, the impact on those rights versus what international law had done or had required in this instance. To the point of Professor Ted on the court being a practical court, there is an approach that the court could look to. The U.S. Supreme Court, for example, in some of the cases when it's confronted by international law issues, has this charming Betsy case, right? They will try to construe domestic proceedings in a way that would be consistent to international law obligations. So for those of us who are thinking about this in our usual monist, dualist concerns about how international plays out in domestic jurisdiction, the charming Betsy case might be an important thing to look at, and whether our court will be receptive based on how it's treated international law issues in the past.
Anything to add? Okay. All right, there seems to be none. All right, so let's move on to the ICC and the interpretation of the Rome Statute. There's been quite a number of interpretations on social media on the various provisions of the Rome Statute. I think Mike and Ross already touched on a few of them. I think we've already discussed Article 59 and of the Rome Statute. And one question, though, perhaps if we have members of the DOJ here, one question that was submitted, I open it up to all of you. One question was, does the DOJ qualify as a competent judicial authority in an arrest made in Philippines? Well, now, of course, the arrest has been completed, but there might be another arrest. I'm not sure. I mean, theoretically, would the DOJ be, would it qualify as a competent judicial authority? May I ask our experts what they think? This is covered by academic freedom, so you may express your views openly. Ross? Oh, okay. Can we have another mic? Yes.
To answer this, I'll refer back to the commentaries of highly regarded publicists, which is that it's interpreted by some commentators as pertaining to a court. But there was, I think, a DOJ press conference yesterday that somehow touched on this, but it was not a categorical response on the part of the DOJ. So, as much as I want to expound on this, there might be some real-time considerations that strategically we have to consider when approaching this question. So, my response is mainly anchored on the interpretation of international legal scholars that it must be a court.
Okay, thank you. Mike, you want to say something?
I agree that textually, well, it says judicial, and in the Philippines, I think we don't understand judicial to be anything other than a court, and even the courts say that a lot when they talk about their contempt powers. But I do want to refer to the case that Judge Pangalangan had earlier mentioned, the Ongwen case. In that case, I think he was brought to somebody called Prosecutor General du Corps d'Appel, and that was considered by the pretrial chamber as sufficient in that case, although that body or that person, based on crude translation that had been done, is a prosecutor general, although of a court. So how that mechanism plays out in the CAR might be different. So if we are trying to look for whether some other jurisdiction had treated a non-court, strictly speaking, as a competent judicial authority, that might be something to look into.
All right. One of the things that have come up as well is the possibility of President Duterte, former President Duterte, having his interim remedies like what happens to Duterte, according to the question, should this interim release by Article 59(3) of the Rome Statute be granted? First of all, is this possible? And if it is possible, will he be placed on house arrest or will he be completely free? How does this work? Mike?
So it will no longer be a 59-3 situation because that applies in the custodial state. So here we're already, the Rome statute does say that there's an opportunity to apply for that interim release during the initial appearance. We don't know if that, it's likely, but we don't know if they're going to apply for that interim release. But on the presentation earlier that I had, mentioned certain conditions that if the court grants that interim release would impose on the person would be released. And one of those is, will specify an address, in this case because there's a release and it's not a detention facility, specify an address and not go beyond certain parameters or radius from that address. So there'll be freedom of movement, but pretty limited still. And we know why that is, so that, of course, the person can appear during trial and will not escape the jurisdiction of the court.
Oh, so in other words, just to be clear, that doesn't mean going back to Davao.
No.
Okay.
I don't think so. I mean, maybe Judge Raul can say whether the court had done that in the past, but I doubt the court would allow leaving the Hague at least for a person who is under interim release.
Judge Raul, would you have any? Yeah.
Yeah, I'm so glad Mike mentioned that. In fact, it was done in Kenya, Kenyatta. He was the president, sitting president. He was charged. He was allowed liberty to go back in deference. He was a sitting president then. And eventually the cases were dropped because the witnesses started, well, vanishing. So I think if you go by the actual historical record and judicial precedent, I think the court will have to be assured that the release of the accused will not lead to more intimidation of witnesses, more suppression of evidence, or the repetition and continuation of the crimes of which the accused is charged. I mean, those are the requirements for the issuance of the warrant of arrest to start with. And so if I'm pretty sure counsel for ex-President Duterte will make a move, will ask for his liberty pending the trial. But the court will have to be assured that all those mischief that I mentioned earlier will not happen. Otherwise, it will just be the continuation of the very injustice that the court is trying to correct.
Thank you, Jess. Sort of connected to that, although Mike discussed that the age of the president, former president, is not a factor. But one question was, what about medical conditions? So connected to the interim release question was a question about whether a hospital arrest would be likely given the perceived frailness of the president.
Let me give that a shot, Rommel. I have actually visited the insides of the jail at Scheveningen, because as a new judge, they basically gave me a tour. But they were, by the way, they were very careful. They made sure that none of the prisoners would see me. You see the Dutch penitentiary close to the ICC, where ex-President Duterte is held. It's very close. It's like 7 minutes by bicycle. It's a modern facility. It is actually largely empty because I think my hunch is that they have legalized drugs, so they don't have enough prisoners, so they can now fill up the space with people who kill drug users. But I don't think the usual Philippine practice of having. I'm sorry. I don't think the Philippine practice of sending VIP patients to a hospital will well fits the situation at The Hague because the jails there have excellent facilities, and I think any needs by the patient, short of grave medical emergencies, can be addressed by existing facilities in their penitentiary. Uh, I have seen the conditions. I have been assured that the prisoners are cared for by the latest scientific standards. Uh, the diet is culturally and religiously is attuned to the cultural and religious needs of the accused. So for the time when most of the prisoners were from Africa, the staple would be maize or cassava or plantain or couscous. But maybe now they should start shopping around for rice and some Filipino goodies. So for me the scenario of using the medical excuse as a way to get into some VIP arrangement in the hospital, I don't think it is viable in the ICC situation. I don't hear anything.
Be used as evidence during the Duterte trial, considering the government's stand that we will not cooperate. So how does that work?
So if you've read through the request for the issuance of a warrant, they even referred to the archive of speeches in the PCO website. So in international criminal investigations and case build-up, we also rely on open source information and may treat this, of course, pending and will undergo a probative value assessment of how they are relevant and how they are able to link to the crimes that are being charged. These may be used, perhaps I think it will be used as open source evidence, similar to what, or how they treated the PCO archives, the pronouncements of President Duterte he made during his presidency, alluding to ordering killings through the drug war. So my view is that, my position is that it can be used as evidence despite the pronouncement of the Philippine government that it will not cooperate.
Okay, thank you. Any other comment on that point?
Just a general comment that it's also possible because, and one difference that might strike Philippine practitioners is that the admissibility of evidence rule would not be as strict as what we have in our rules of court. So that might be also a point for the admissibility. And as Ross mentioned, the analysis is a probative value analysis of the evidence taken as a whole.
Thank you, Mike. I'm going back to Professor Tev. We have a new question involving the Supreme Court. The question reads, for academic purposes, will the... the person wants to be protected as well, although I don't know who asked. Will the writ of amparo be available as a remedy for the former president?
I do not believe so. The writ of amparo is a special writ that is designed to address violations or threats of violations to the right to life, liberty, and security. And there is a special focus under the rules for those who are victimized by extrajudicial killings and enforced disappearances. Based on jurisprudence, I do not believe that this would fall under the definition of the scope of the writ of amparo. And besides, again, the usual question, whether the writ can travel across borders. So I don't think so. Although, of course, the court is currently reviewing the writ of amparo as well, with the end of possibly revising or even rewriting the writ. So if the court is listening, it might be looking towards adding more things. But Mike has also worked extensively on that, and so Mike would probably have some input.
Okay, go ahead, Mike.
Just to add to what Professor Ted said, it's also incompatible, or it's not in line with what amparo is for. Because in this particular instance, we know exactly where the former president is, and we know exactly what protections there are and what accommodations are given. So it's not like a situation of enforced disappearance or some other violation where we're left, to find information elsewhere, and therefore is asking the court for assistance in that aspect.
Okay, thank you very much. Now, one criticism about the entire process is that it's, previous to this, the President Marcos Jr. said that he will never cooperate, but then you have this whirlwind arrest and transfer of former President Duterte. So the argument is that, well, this is really politically driven, right? So what if the political winds change such that in the future, I don't know how far into the future, the administration decides, no, we want him back. Can, for example, during the course of the proceedings, the Philippine government requests that Duterte instead be tried in the Philippines, maybe to answer to a case that is filed in the Philippines? I mean, has that ever been done? Can a country like the Philippines ask the ICC, actually, we changed our mind, can you bring him back, we will try him here? Is there a mechanism for that? Or once a person or accused has been transferred to The Hague, there's parang touch move, no? You can't have him back. Has that ever been done, or is that even possible? I guess that's the tenor of the question. Any thoughts on the matter?
Sir.
Well, there are
this
things-
is not to answer the question,
Okay,
but to
go ahead, go ahead.
reference what we call. So when we've done, in my experience, doing all of these international criminal investigations in other jurisdictions, there is this phrase that we usually invoke, which is the political window of opportunity to prosecute international crimes. And once that opens up, even for a tiny bit, we latch on to that and hope for the best. So it's not a legal answer, but it is part of the case building process that in the field we always look out for if there is an opening of that political window of opportunity, and then that's where the documentation, the richness of the information that was gathered prior, that's where it comes in. That's where it becomes, now, madali na siyang immobilize, i-systematize, and i-organize to build the portfolio or the dossier that could be used to bring the case moving forward.
Okay, brilliant answer, Ross. All right, if there's, yes,
no,
Judge
can I-
Gold.
I'll give this a shot, but I'll ask for Teddy's help later. Okay, Teddy, I'm putting you on notice. I haven't encountered that situation. Just to start with, I don't recall any situation having of that nature before the ICC. But Rommel, the scenario that you described just might happen, and you're right. If you go by the principle of complementarity, if the court says, "Hey, with a change of government, we're now actually in a position to do this ourselves," and I will assume, Rommel, that is a bona fide assurance, not a subterfuge to get the fellow off the hook. So, assuming all those bona fides, I imagine the court might say that, yeah, that's the principle of complementarity. But Teddy, here I turn to you. I don't know how that can be done procedurally. I mean, what will the prosecution say? They file a motion to dismiss? I mean, the trial has been going on. I mean, and assume that it is after the prosecution has completed the presentation of evidence. The court will already have enough information, I assume, to surmount the test of proof beyond reasonable doubt. I'm completely at a loss. What motion will be filed? And how to justify it in a way that is compatible with the courts having been seized of jurisdiction over the case. I'm at a loss on that point. But Teddy, I don't know if you have some ideas here.
Judge, I also cannot imagine that scenario. And, because again, the opportunity was there for many years to prosecute him, which they did not take, which they did not do. In fact, many people were talking about Republic Act 9851, which would have been the perfect opportunity to essentially keep him here. Because had they filed it, then they could invoke exactly complementarity and prevent a trial at the ICC. But since they didn't do it, and even assuming that, as Judge Raul puts it, the possibility that the shift in political winds might come up and present this opportunity where they could now say, we are now in a position to prosecute him here and here. So ICC, here's the information. We are in fact charging him. We want him back. Can you bring him back? I cannot see what motion, what document would be filed by the prosecutor and the ICC to say, okay, we're giving him back to the Philippines. So at this point, I really cannot.
Okay. Since that's such a difficult question, that seems to be a good final exam question for PIL or International Criminal Law, so notice to all students. It's sort of connected to a question that was asked also during registration. The question reads, in light of Putin and Netanyahu's non-arrest, despite an ICC-issued warrant, is the swift handover by the Philippine government of President Rodrigo Duterte to the ICC, while its judicial system is functioning, a signaling that the ICC is highly vulnerable to politicization in weaker states? So it's a bit of, might go into the criticism that Ross was alluding to a while ago. So perhaps you can comment on that, Ross?
So I don't know if I still have students here, but I think the first question, one of the first questions that I always pose at the beginning of the PIL class is, okay, this is the problem with international law today, at least according to the critical wing of the scholarship. It has an imperial colonial history. Traditionally, it has served the ends of the global north, and yet it is all we know. It is all we know. So it's sort of what could be another coherent, intact system that could enforce all of these rules, all of these norms, as an alternative to international law. But until we get to that point in time, international law is what we have. And the prosecutor, in his statement regarding the arrest, he kind of alluded to this as well. He said, some say international law is weak, but this is one way of showing that something at least is moving and is happening, and it's not really as weak as we think it is.
Okay. Yes, Mike.
Yeah, I don't think it's a vulnerability. In fact, I think it's a boon to the ICC that states are willing to cooperate. I think these possibilities had existed even before this case anyway. In this instance, we have a political context that facilitated it. But from the perspective of the court, I don't think that matters much as long as the person is surrendered and procedure is followed and fair trial is given. So whatever the political context that facilitates the performance of the court's mandate is something good for the institution.
Thank you. Speaking of arrest, I guess an arrest on our mind as well, that's alluded to a while ago. This may involve everyone in the panel. I guess it comes in two parts. The question posed was, can the Senate protect Bato de la Rosa in case a warrant of arrest is, this is covered by academic freedom, in case a warrant of arrest is also issued against it? I mean, meaning, I guess there are two layers to that. One, can the Senate do that? Second, will the same procedure work against Senator De La Rosa, considering that he is still a sitting senator, at least for a few more months? We don't know how the election will turn out. But I mean, so two things. I mean, can the Senate protect him, and whether the same process that they did for former President Duterte can also be applied to Senator De La Rosa? So I guess starting off with Prof. Ted.
With the exception of Senator De Lima, the Senate has a track record of protecting its own against writs. And I think the Constitution also says that, Section 11, a senator shall, in all offenses punishable by not more than 6 years, be privileged from arrest while the Congress is in session. So 2 points. Congress must be in session. 2, the offense and the penalty. So here, it might be an open question, right? Because you're talking about an ICC warrant. There's no predetermined penalty because it only happens once there's a sentencing. So this provision might not be squarely applicable. Whether the Senate will protect Senator De La Rosa, again, I think it's a question for the Senate as an institution. But I think from track record, if there are, warrants or orders against senators, again, I think with the exception of Senator De Lima, the Senate basically, takes a position and says we will protect, we will not let them, come here and arrest them. So I don't know really, but I think that Judge Raul pointed out that we're talking about sui generis questions here. This would be precisely one of those, because here you're talking about an ICC arrest warrant. You're talking about a senator who may be re-elected, right, while Congress is not in session. So there is that window that Ross was mentioning, right? And we know when that window will end. So maybe that's the period that we're talking about.
Okay, thank you, Professor Ted. Yes, Mike.
Yeah, I'm just thinking about what Professor Ted said, and I don't mean to help any legal team for any future legal problem. But one of the cases that we encountered before, I think with a sitting member of the House of Representatives, and the argument that was made was this was an enfranchisement issue. And the court in that case didn't think much of that argument because he was going to be in the Philippines anyway. There was not much hindrance in performing the job. In fact, senators who had been incarcerated in the past had been able to do their jobs as senators. But the interesting twist here is if the person is not in the jurisdiction, and whether the enfranchisement issue, not that, we're making judgments about whether they are representing their constituents in any form, even now, but if someone is outside of the jurisdiction, whether that mandate that had been given through an election might matter in how a court resolves whether, being detained somewhere, even while sitting in office, is an issue.
Okay. All right, thank you. There's this question here. I must confess I don't fully understand, but since I'm not an expert, I will let you decide. The question is there a state witness discharge concept in the ICC? Trillanes said Las Cañas and Matobato have been in the ICC even before the arrest of the former president. What do you think of this question? Maybe Ross or Mike?
So, in international criminal investigations, case build-up, you have different classes of witnesses. So, not just the eyewitnesses or the crime witnesses, but you also, and more importantly, you also have to consider the insider witnesses. Okay? Insider witnesses could be former members of the perpetrator group, could be perpetrators themselves, and this is a question that is handled with a lot of delicacy in other investigations. So at least what I'm speaking from the contexts that I worked in, very politically sensitive contexts, there is that lingering question of if we start treating low-level perpetrators, or at least mid-level perpetrators as insider witnesses? What could be the effect or the unintended consequence related to that? But at least in the practice of international criminal tribunals, insider witnesses have been very, very crucial, not just to prove the specific killings, but to prove the linkage, which is the chain of command. How does the organizational structure look like? What are the incentive structures? What are the reward structures? How do you carry out orders? So I'd like to point out one instance in the Quadcom. Someone, was it the former police chief, I forgot her name, Garma, I think, yeah, covered by academic freedom. Garma presented, reduced into an affidavit, at least the chain of command or the pattern of giving out orders where she was stationed. And that, I think, is a very good example of how insider witnesses could be very crucial in terms of linking, kaya nga siya linkage evidence, linking the pattern of criminality to the specific crimes, okay? And who may be responsible. So yung state discharge, I'm not sure how to approach that, but just for the purpose of this question, it is possible to have them stand as witnesses in the ICC.
Okay, thank you. Mike?
I imagine the analog would be like state witnesses and whistleblowers. So I would say that it might not be a really big question or a relevant question when you look at the practice of the court as well as the history of international criminal tribunals. So it's particularly important in this indirect co-perpetration mode of liability or attribution because it is anchored on the idea of the hierarchy control theory, and therefore it structures the priorities in prosecution so that those most responsible are prosecuted under this theory. And if you look at as well the history of international criminal tribunals prosecution, but here and there you see prosecutions of foot soldiers or somebody low in the chain. But given the resources, time, effort, and of course finances, it might not be such a relevant question, or the fear might not be so big. So that's to say that if there's somebody who wants to participate as an insider witness and is concerned about immunity before the court, that might be less of a concern given the practice of the court in the past.
I guess a related question. There was, I think, a discussion from Judge Raul a while ago, and perhaps Ross as well, when she talked about the evidence. There was a discussion on like a video conferring kind of testimony. I think that was mentioned. A question says, or writes, a significant number of crimes attributed to Duterte occurred in Davao. What are the protections accorded to the possible witnesses, especially those coming from his stronghold? So in a sense, this might be via video, but I guess the question goes into anonymity. Is it possible to testify without your identity being disclosed, I guess? Or so the question is, are they able to testify in anonymity, or what can be done for those who want to testify but are too scared to do so, knowing the power currently held by the Duterte name?
So there is a mechanism in the court where victims or witnesses can request for the redaction of their names and their information in what would be released to the public. So within the court, there is a unit, the Victims and Witnesses Unit, that could make arrangements as to how to protect the witnesses or how to facilitate their testimony remotely. And I think this is, broadly speaking, this is also something to think about when we think about international crimes. International crimes such as war crimes, genocide, crimes against humanity. More or less, but not all the time, more or less, it's perpetrated by a highly organized group. Sometimes it's the state itself. And the difficulty there in accessing the witnesses is, how do you then encourage witnesses to come out and testify if the state is quite hostile to them? and they will face the risk of disappearing or being intimidated and their testimonies being tampered with. So I think it's built into the nature of international criminal investigations that you will always have this consideration. So within the court, there are available mechanisms, and one of which is to redact their publicly accessible information.
Okay. Yes,
I'll-
Judge, go ahead.
I will add to, I'll give actual examples to what Ross mentioned. So yes, absolutely. The court has this unit to protect victims, to protect their identities. Um, the, the court goes to great lengths to protect that. So for instance, uh, the redacted testimonies are there. The measures to ensure that they can leave the witnesses can leave their villages and come to The Hague is kept under seal. There are limits to what the court can do. I'll give you a concrete example. If they are brought, like in one case, lots of rape victims, they would testify before the court. Well, we can keep it a secret, but if they leave their village to go to the city and they're asked by their neighbors, why did you go there? If they applied for a visa, so the next question is, hey, why do you need a visa? Also, when they testify before the court will furnish them a proper attire to be in the courtroom. And if they bring home dresses from Europe, again, the neighbors will be able to detect that. So there are limits also to the anonymity that the court can provide. The court also relies on assurances from defense counsel, and that is why it is important to have competent and really professional defense counsel, because counsel will be informed of the identity of the witnesses. And uh, uh, under an oath that he or she will respect that confidentiality. And we, of course, are aware of practices in our own country where those oaths are violated. And I think the units in the ICC in charge of protecting the anonymity of witnesses will have to, how should I say this, update themselves on the ways by which anonymity can be violated in the Philippines. Thank you, Romel.
Sort of connected to that as well. It deals with evidence. The question reads, human rights defenders collected and preserved evidence while Duterte was in power. But since then, it is possible that the witnesses have died or changed their minds and would no longer be willing to testify before the ICC. Would such change of circumstances, I mean, the witness already being dead or they've changed their minds, hamper the admissibility of the initial evidence collected? So I imagine maybe the testimony was recorded in some way, but the ones who gave their testimony might have died or they've changed their minds. I guess the question is, those recordings, whether written or video, would those still be admissible? So anyone? Yes, Ross?
Preliminarily, this was already alluded to by Mike. There is a very narrow exclusionary rule under the Rome Statute. But the court, again, will have to examine if a certain piece of evidence will have to be excluded on the ground of, one ground, if I remember correctly, is if it is not actually related to or it's not very much tied to the crime being charged. But, and Judge Raul may correct me on this, I am quite, I remember that there is no strict hearsay rule under the rules, under the Rome Statute. So what
I
are
confirm
common...
that you're correct.
Okay,
You're
correct.
correct.
Okay. So there is no hearsay rule as we know it in domestic procedure. And again, open source evidence is also available. So the probative value assessment will look at how relevant the evidence is to the crimes being charged.
Okay, thank you. Mike, you wanted to add?
Yes, that's right. And there's actually a rule, Rule 68 of the Rules of Procedure that deals exactly with that prior recorded testimony. There are certain categories of witnesses. You can present a witness's video or prior recorded testimony without anything from the witness if there had been opportunity on the part of the prosecutor and the defense counsel to examine during the recording, but that might not be relevant in that scenario that you mentioned. But paragraph C of Rule 68 does talk about a witness who had died. And so in that case, it might be relevant and therefore the prior recorded testimony might be admissible. For witnesses, though, that are still alive, the rule does require a statement that the witness, some authentication or attestation on the part of the witness. So I don't know how that might be feasible, but to the gist of it is that it's allowed prior recorded testimony.
Rommel? Rommel?
Yes,
Am
go
I-
ahead. Go ahead. Go ahead.
Okay. Thank you. Thank you, Rommel. Well, on this point of the witnesses already dead, there is well, I've mentioned earlier that I have many of the lawyers assisting the Filipino victims are my former students. There is actually one group which has one real advantage in this entire proceeding, that is center law, because they are representing the one single Tokhang survivor, this fellow Efren Morillo, who pretended that he was dead and who played dead and managed to survive and to live to tell his story. And that is also one case which demonstrates the problem of complementarity, because despite the overwhelming evidence in this case, our authorities have not moved forward. So I think this is a situation, in the case handled by center law, where the witness is available. I'd like to also follow the point of Ross on hearsay evidence, and also just to explain, because again, a local audience might recoil at this thought. You see, many of the rules of evidence are designed to insulate a lay jury from improper evidence, and the ICC is designed along the lines of continental courts, where the findings of fact are made not by laymen, but by three legally trained judges, and so they do not need to be insulated from evidence, and should be free to appreciate on their own, for themselves, the probative value of the evidence before them, which thus explains why the traditional rules in the common law system are not present in the continental law system. Thank you, Rommel.
Not so much a legal question, but I guess it calls for an opinion. So I guess I'll ask for your opinion. Is the surrender of Duterte a tacit admission to the public that the justice system in the Philippines is not working or is selective? Are there negative implications that are that we have to mitigate? So I guess the surrender as an admission that there's something wrong with the judicial, so it's taken in a negative light. So, and I guess that's coming from a number of social media posts as well, saying that, why are you surrendering to a sovereign power? You're making us look bad. We have functioning courts. I guess that's the thinking here, I imagine, behind the question. So, yes, Mike, I think you raised your hand first.
Yeah, I think we actually hear a lot of that even in the complementarity arguments before. And there's been this characterization of courts or states as, or like lumping, that if we give in to the ICC, then it seems like we are okay with being in the company of states whose judicial systems I don't think that's the case, even under complementarity. I mean, what you really just want to check is if there's an investigation or prosecution at all, and that's not, indicative of whether your judicial systems are functioning. That's really more whether that effort is being exerted. So, as a matter of system, it doesn't follow that you surrender somebody. I mean, I think everybody can read the political context as well. I mean, our courts are functioning, but that's just not how this played out because of other considerations and not because of how our judicial system is structured.
Romel, can I jump in again?
Oh, sure,
Judge.
Judge.
Well, not necessarily. It's not like us, the equivalent of us saying, yeah, we have a terrible judicial system, and why don't you do the job for us, the job that we can't do ourselves? Of course, that's possible, but not necessarily. Because in the ICC, there is what we call the self-referral. And again, the example is the Onguwen case that I mentioned earlier. It was the president of Uganda asking the court to take over the prosecution of certain cases, saying that I would rather that this case be litigated by independent judges outside Uganda than within my country. And the self-referral is a mechanism by which a state basically, asks the ICC to take over a trial that they prefer not to be litigated within their domestic jurisdiction. So, going back to the question that you asked, my answer is it is not necessarily an admission of failure.
And connected to Mike and Judge Raul's point, the ICC by design will be very sensitive to any state activity. It's very sensitive to any state activity because any state activity could very well feed into any arguments that may touch upon complementarity. So it will be very attuned to what the state will do next. So it is not, just to drive the point home, it is not necessarily a full surrender to the court's processes and admission that nothing is happening. In fact, the court can recognize that the state is doing something on its own.
Thank you. There are two questions that are similar, so I'll try to combine them. It deals with going back to the Rome Statute. Right? I guess the question, it wasn't asked, but it's implied. In the first place, would it be possible for the Philippines to rejoin the Rome Statute? And if the current administration would want to go back to the Rome Statute, how will it affect the current trial of Duterte? I mean, would if for some reason we decide to go back to the Rome Statute, would that in any way affect what is happening in the trial of former President Duterte? Would it weaken or strengthen? I mean, would there be any effect? Anyone? First of all, let's deal with the threshold question. Is it possible to go back?
Just a short answer, Romel. Yes, of course, it's very possible to go back, and if we do, it's good news. I mean, it strengthens the hand of the court in proceeding with the case. It simplifies, for instance, the matter of judicial cooperation, of securing evidence, protecting witnesses. So overall, that would assist in moving forward with the case.
Familiar if there's a specific procedure under the Rome Statute for a state who was previously a party, withdrew and wants to come back. Will it be a fresh accession to the Rome Statute, or is there a quicker way for a former member, or do you have to go through the accession process again?
The quickest is just to withdraw the withdrawal. I mean, it was a sovereign that withdrew, and the sovereign can just withdraw the withdrawal notice. But if the Assembly of States Parties accept it, then we are technically members all over again. It's almost like there was just a dark chapter and we put it behind us. But I've seen larger debates on this issue. Some people saying that we should go through a ratification process all over again, but we can't resolve that in this forum.
Pangilinan versus Cayetana Part 2. I mean,
Yeah.
if the withdrawal does not require Senate concurrence, will a withdrawal of a withdrawal require Senate concurrence? Probably not. Well, I don't know. But so it's possible, but I think you already partly answered the question, Judge, that it would make the process go faster because as a party we would have obligations under the Rome Statute, even though there's an interim period that we were not a party. Would that be a correct assessment?
That is correct, yes.
Okay. All right. I'm running out of questions. So if anyone else would like to ask questions, please post it on the. You can send it to any of our staff or use the QR code.
Rommel, I was giving very short answers because I thought you were out of time, but I can actually add to that. If the Philippines simply wants to cooperate more fully with the court, without having to deal with all the difficulties of ratifying or withdrawing a withdrawal, there is a very simple way under the Rome Statute, Article 12, Paragraph 3, that is ad hoc submission to the jurisdiction of the court. It actually, like Ukraine is not a member of the ICC, and yet the court has issued a warrant of arrest for Putin for his invasion of Ukraine. And that is via the ad hoc submission. That is a way by which a state, which is not a member of the Rome Statute, says, look, I'm not a member, but can I submit this matter, this problem, to you for your investigation and prosecution? And that is not a treaty. So, well, Rommel, of course, you can anticipate all the difficulties here. It is not a treaty, therefore it's not covered by the treaty clause. It will be a pure executive decision. But once we make an Article 12, Paragraph 3 submission, then we are back subject to the jurisdiction of the court.
There's actually a connected question to that scenario we discussed earlier, that what if the Philippines goes back? The question is, if the Philippines were to withdraw its withdrawal to the Rome Statute, would this retroactively restore the ICC's jurisdiction over crimes committed during the period between the country's withdrawal and its reaccession? Would the ICC still have the authority to investigate those offenses committed within this gap period?
Mga pang-final exam to, Rommel. So,
Suggestion I will.
or maybe for a moot court.
Yeah.
I leave it at that.
One would like to hazard an answer. Well, I don't think so. Well, speaking purely for non-ICL expert, just purely speaking from a VCLT point of view, because you cannot retroactively apply, right? I mean, of course, the problem here is it's not a new treaty, but a withdrawal of a withdrawal. So this is a very good final exam question. But if you apply the VCLT, I don't think you can, because it would be a retroactive. Besides, it's criminal law, so it has to be prospective, right? So I guess while this is a gray area, it would lean more towards a no. Yeah, prospective. Yeah. So that ends my question. So do we have questions from the floor? Are there new questions that were? Oh, sorry, there's new. Under which heading? The political questions. Okay. Okay, I guess this is a political question. So the question is, if my understanding is correct that the ICC is more or less a court of last resort, it seems to highlight a lack of any transitional justice mechanism in the Philippines. The drug war was very popular, served by the timidity of the profession and law schools. and in many ways is the failure of the Philippine society. How does Duterte's prosecution figure in the social reckoning? Does it further social accountability or only papers over the cracks? Sounds like one of your students, Ross.
Preliminary response to that. I'll
Ikaw eh.
point you to
Oh, Professor Tamase owned to the question.
I'll point to the example of the dictatorship of Ferdinand Marcos Sr. The law that provided for the transitional justice mechanism, RA 10368, became a law during the time of Benigno Aquino III. So the span of time that was in the interim between the mass atrocity event and the transitional justice mechanism, matagal. So it was quite long, and until now, the full implementation of RA 10368, and Ma'am Glens is here, Attorney Glens is here, who was a board member of the HRVCB, where I first worked as a lawyer. In terms of the memorialization process, we still have lingering issues regarding that. And even outside the context of the Philippines, transitional justice experiences elsewhere took a long period of time because exactly the point of reckoning, and if you look at what's the conversation happening now, it's a very polarizing, still polarizing, divisive issue. And transitional justice mechanisms, it's usually a look back into time. So the processes attached to that quite long, especially for, I would suppose, the Philippines after Duterte would be a post-authoritarian regime. So post-conflict, post-authoritarian regimes are the usual contexts by which transitional justice mechanisms are happening. So accountability in terms of criminal accountability is one way to signal that we have taken steps, and the other pillars of transitional justice, not just reparations, but also, and not just accountability, but also non-repetition. It sends out the message that, hey, if you do this, if you commit mass atrocities and crimes against humanity, if you orchestrate them, this is what will happen to you. So it is a dimension of transitional justice, but it might take a while before we get to that point.
Okay. Well, in the context of, Mike, you want to say something? Okay. In the context of things taking a while, the question here reads, if former President Duterte were to pass away while ICC proceedings are ongoing, what would be the legal consequences aside from termination of the case? Could reparations still be ordered for the victims? In the absence of a final conviction, could his estate or heirs be held civilly liable under either ICC mechanisms or our own domestic law? So first of all, I guess, has that ever happened? Has a person accused died before the trial ends? And if that happens, what happens to the case? Does the civil aspect, I guess, continue? I guess that's the tenor of the question.
Well, the fundamental rule is that reparations, the victims get reparations only if the accused is actually convicted. And if the accused dies before conviction, then there is no conviction and no reparations are due. What the court does to ease that situation is that there is a trust fund for victims, so that, and the trust fund has two mandates: the judicial mandate to carry out an award and the assistance mandate. And in this case, that is what they do to assist the victims who could have collected reparations had the accused lived until the end of the trial. But your other question, Rommel, about attaching assets, categorical, yes. The court attaches the assets of the accused to answer for liabilities to his victims. I have sat in one of those cases. It was quite impressive, Rommel. The report of all the assets of the accused, even those hidden, registered under names of relatives, are covered by those reports, and they are as comprehensive as they get. In fact, when I first saw one such report, I wondered why we couldn't do similar reports in the Philippines to track down the assets available to make them answer for their liabilities. So yes, the quick answer is yes. The power to attach is there under the Rome Statute, and yes, it has been exercised.
Okay. Thank you, Judge. A procedural question also that was just added was, would plea bargaining be available? Would it lower the penalty? Is that something that is done in the ICC? Plea bargaining.
Well, they don't call it plea bargaining, but if you look at the record, you will notice that some sort of assurances were made, and but they are crafted very well. But let me just, I don't want to go into more detail, but it has happened. I can confirm that.
Okay. Do we have any more questions that are new? Is that it? Oh, wait, there's one more. Sorry. Let me read this last question. It says, considering that former President Rodrigo Duterte is the first Asian leader to be subjected to the jurisdiction of the International Criminal Court, what implications does this have for the Philippines' political standing within the Southeast Asia and the broader Asian region? Additionally, in the context of President Bongbong Marcos, does the ICC's assertion of jurisdiction over a former head of state establish a precedent that could influence the potential liability of future leaders under the ICC framework? So there are two questions there. First, on the issue of how does this affect the Philippines' standing, I guess it's referring to ASEAN and or Southeast Asia or Asia, and does it set a precedent for against future leaders of the country? So, do you have any comment on that question?
Let me give it a shot, Ramel. There is actually another outstanding warrant of arrest from Asia for one of the Myanmar generals for the genocide against the Rohingya. So if the question is what message does it send, I think it does send the message that the ICC, that justice is possible through the ICC, and that it has a real there's a real bite from the Rome Statute. Of course, I acknowledge the political contingencies. That the stars have to align for certain things to happen. But that is a fact of life anyway in legal proceedings. Look at the leading case in constitutional law. Typically, constitutional law starts with Marbury versus Madison, the power of judicial review. That was a very heavy ruling on the power of the courts to override decisions by other branches of government. And yet it arose from a minor incident on the delivery of a judicial appointment, caught in the middle of a transition from one outgoing president to another. And the case law, the legal history abounds in many of these coincidences and strange combinations of events. Which is actually caught in the classic work by Carl Llewellyn. He described the law as a bramble bush, almost the arbitrary growing of thickets along the way. For me, just to wind up this long explanation, yes, this development is a milestone for especially for the role of the ICC, especially in Asia. And Asia is the least represented region all over the world when it comes to the Rome Statute. So I hope it is a move forward for Asia.
And that we have one more question. I guess they don't want to let you go yet, Judge. But I just want to mention, when you mentioned Marbury versus Madison, there was a collective sigh from the law students in the room. So it brings back memories. All right, the question reads, there was a rumor that former President Duterte was in Hong Kong to ask for asylum from China, but such was not granted. Hypothetically, how differently would the ICC case run had he been granted asylum, especially knowing that China is not a state party? If the ICC cannot try an accused in absentia, would it have meant that the case would remain pending for however long? Or is there a period provided wherein if the threshold time is surpassed, the case would be dismissed? So I guess some kind of prescription, I guess. So I guess the question, in a hypothetical situation, had President Duterte stayed in Hong Kong or in China or has been granted asylum, how differently would things have played out, and would there be a prescriptive period?
Just a short answer, Rommel, then Duterte would not have been arrested because he would have found sanctuary in China, and China will not be under any obligation to deliver him to ICC authorities, and they can wait it out and for as long as they want, and the case won't move forward. That is the situation of Joseph Kony, or for that matter, al-Bashir. They are not in the jurisdiction of the court. The warrants remain outstanding, but there is no prescriptive period. The liability does not expire.
Clarification. So I suppose, having no further questions on that note, let me give my closing remarks. To close our event, I'd like to thank our expert speakers, especially those who are on the other side of the world, who have given up sleep, not only today, but the past few days, giving interviews, in the hope of informing and educating our people about what is transpiring in our part of the world. Today, we heard very enlightening views. Professor Mike Chu walked us through the basic legal texts and definitions to help us understand exactly what the law says and what the law requires. Professor Ted discussed the domestic law issues and what might or may not happen because of the Supreme Court cases. Professor Tugade talked about the manner of proving crimes against humanity, the evidence gathering, and the types of evidence that would be required. Judge Raul Pangalangan shared his insights that only a former ICC judge could possibly give. And we thank him for his insider information and insights on international criminal law. And it does bring us back to our classroom when he was our professor. So this colloquium is significant for many reasons. I can give you three at this point. First, this colloquium fulfills the mandate of the host institutions, the UP College of Law and the UP Law Centers Institute for International Legal Studies. The College of Law is the premier law school of the country, tasked with educating the public on public legal matters of national importance. The Institute, on the other hand, is tasked with undertaking research and extension services in international law and international relations. And one of our research programs is led by Professor Mike Chu, the International Criminal Law Program, which has been very active over the years following this issue, and possibly following it for a few more years until its final termination. The second reason why this colloquium is significant is because we need to clarify the complex legal issues surrounding our topic today. As Dean Lelen earlier in her opening remarks says, there's a need to clarify the complex legal terms because apparently even some lawyers are confused. And this colloquium is a way to present the issues, as Judge Pangalangan pointed out, without partisan posturing. It's a completely academic and objective way of looking at the issues. Sadly, confusing and conflicting views have mushroomed in traditional and social media with so-called self-proclaimed experts. Hopefully, because of the colloquium today, we can better grasp the proper legal analysis of the situation. And thirdly, this colloquium has demonstrated the need to understand international law more and perhaps more deeply. Even those who studied international law would agree that the issues in this case go beyond what is usually covered in the classroom, certainly more than what is asked in the bar exam. And if I may add one more significance, this colloquium should help us appreciate the importance of international law in our daily lives. While international law does not crop up as frequently as constitutional or civil law issues, they are no less important. Today, we are fortunate to hear from real experts with the academic credentials and personal experience to support their opinions. I hope this has been a productive afternoon for all of us. Thank you for being here. Thank you for listening. This ends our colloquium. Thank you very much. You are now dismissed.
Mike, kwento tayo.
Yes, Judge.
Later.
Thank you, Judge.
Really?
Thank you, Mike. You can now sleep. Sorry for keeping you up.
Tulog na po kayo.
Okay, guys.
I'll send you a link, Judge. I'll send you a link.
Sige. No, now it's, I want to sleep now.
Okay.
It's 2. I'm in Colorado, Mike.
Oh, wow. Oh,
Yeah.
nice. So you're in Central Time?
Okay, Prof. Betty.